welcome to today's training presentation on the basics of international protection. I'm going to talk about the following issues, just for you to know the menu today. We're going to have an initial part about basic concepts on international protection. Maybe some of you are somehow or a bit familiar with that. We'll talk later about something that is always needed. It's to talk about facts and figures. It's also to remind us all of the volume of the magnitude of the situation worldwide and more locally also. Always remembering that behind every number there's a person, there's a life, there's a story. So that's also very important to take always into account. And we'll talk in a third part a bit more in depth into what I work in my daily work, which is the international protection system in Spain. And there we will talk about, on the one side, how the procedure to determine that a person is a refugee is organized, how it works, and also what support refugees receive in Spain, asylum seekers and refugees receive in Spain. Okay, I'm going to ask you at some points to just provide your views or just for make it a bit more interactive also. And at the end, if we have time, I wanted to make a small test with you. As we are a small group, we can do it all together and comment on it. And please just feel free to make questions at any time. And yeah, I think that's all. So I don't know if you have any questions about what we're going to talk about, or we just start. Okay. Well, I wanted to put a video on for you, which we have been trying to put on screen earlier, Susanna and myself. For some reason, we cannot share the screen and the sound at the same time, so we'll skip that part. I'll share the videos in the presentation that you will have in the Moodle, so there you can watch it. I'm going to tell you instead a bit about what the content of the video is. It's really who we are as the UN Refugee Agency. UNHCR, the United Nations High Commissioner for Refugees, is, as I'm saying, the UN agency for refugees. It was created in 1951 in a very specific moment and time. It was just after First and Second World War, where Europe was facing the situation of millions of refugees that had been left without a home, were not able to return to their homes, and the solution had to be found for them. So the General Assembly of the United Nations decided to create the UNHCR. At that moment, well, it was created with a mandate to find a solution for refugees, providing what is called international protection to persons fleeing conflict and persecution and serious human rights violations. That's what international protection is. When we talk about international protection, we're talking about a person who is suffering either a conflict or serious violations of basic human rights. Because of that, that person cannot avail himself of the protection of his state. He has to leave that state, and at that point, the international community has to provide protection. That's what we call international protection. So that's the mandate for UNHCR, to provide international protections to those who flee. It was created with at that point with a very optimistic view that UNHCR would only be needed to be there for 3 years to deal with the issue of refugees in Europe. The reality is that in 2022, we're still here and we are facing each year record numbers of refugees worldwide. We'll talk later about numbers. So that's who we are. How does UNHCR deliver international protection? We do it by providing direct assistance in refugee situation, in emergency, humanitarian aid, etc. That's maybe the more classical concept of UNHCR in emergencies, in refugee situation, in crisis, providing shelter, providing housing, providing access to sanitation, at refugee camps, etc. But we do work also in advocating for refugees to access the rights they have lost because they had to flee wherever they end up. So when you have to leave your country, you are left without access to your basic rights, without basic to property, without access to documentation, to education, to health, to the possibility to earn and to self-sufficiency. So what we do work for in that sense is to make sure that wherever refugees arrive, the conditions are in place for refugees to regain access to these rights that they have lost. And one of the third aspects we work, it's what I called earlier durable solutions. This means that apart from having access to rights, refugees need to have conditions for them to as I was saying at the start of the meeting, to have to call home a new place. This can be because either they arrive to a place where they integrate, that's called integration as durable solution, because at some point they are able to return to their home country, to the place they came from. Return has always to be voluntarily in security and with dignity for people. So that's the three aspects in which UNHCR promotes return to the countries of origin. And last, or what we call the third solution, is looking for solutions in third countries. That means that when a person cannot go back home, when that person cannot, for different reasons, remain in the country, in the first country of asylum, in the first country where the person sought protection, we try to look for solutions in other countries, in countries that are open to receive refugees. That's done through a specific program that is called resettlement. Through resettlement, UNHCR identifies refugees in first countries of asylum that are at risk, that remain at risk in this first country because of different situations. It can be a legal risk, it can be a risk of facing death, of facing loss of liberty, or even of not having long-term integration perspectives. In this case, we identify these refugees, we approach states indicating, look, these people need a different solution, not in this country. For instance, something that we've had very recent and that we have still is Syrian refugees in Lebanon. Lebanon is a country that is overwhelmed by the number of refugees and has not a structure that is adequate for refugees to remain there for a very long term. So we work in finding other countries that are open to receive refugees that settled first in Lebanon and then are accepted by other countries. So that's the areas in which we work. That's all that the video was going to tell you, but I invite you to see it later. And also it will allow you to know a bit about what has been the history, let's say, of the plight of refugees since the UNHCR was created to our days. Something that is very important when you talk about international protection is that we have a legal framework. I'm a lawyer myself, so I'll try to adapt my language and the way I tell you things, but please tell me if I don't adapt well. And also in English, it's frequently an added challenge. So besides of creating the UNHCR as the agency to protect refugees, what the General Assembly of the United Nations did back in 1951 was to draft the Geneva Convention for Refugees. That establishes the Statute of Refugees, and that was completed in 1967 through an additional protocol. So these are the two key legal documents on refugee protection. I stress that because that's a big difference when we talk about the people that are displaced in the world, that are on the move, that do migrate or flee. In the case of refugees, we have something very important, which is an international legal framework to which states that have ratified it are obliged, which we do not have with other migratory populations. So that's a very important point, and that's something that allows us to really point out to states when they are or they are not complying with their international obligations in a very strong way. So as I say, the Geneva Convention and the 1967 protocol, which lifted all these geographic and time limitations that I was telling you at the start that were there when UNHCR was created. These two are the key legal documents on refugee protection. What do they include? They define the term refugee. The Geneva Convention establishes a definition of what a refugee is. We're going to see it in a minute and talk about it. It also contains what the rights of refugees are and should be in a country where they are admitted as refugees, and the legal obligations of states to protect these refugees. And the other aspect, the very important aspect, and which is what is called the cornerstone of international protection, is that the Geneva Convention in its Article 33 establishes the principle of non-refoulement, which we use the French term. We will talk later about this, but it has to do with not putting people, not sending a person back to a country where his life or his liberty or his integrity is under threat. So these two documents, the Geneva Convention and the 1967 protocol, mainly the 1951 Geneva Convention, is the basic legal document on refugee protection. And I will be mentioning it throughout the afternoon many times. It's also important to know that as a cornerstone of the international protection regime, this means that all countries that have ratified it, and it's 149 countries worldwide, among them, of course, Germany, Sweden, and Spain. Germany and Sweden were some of the first countries that I think it was 1953 and 1954 to ratify the convention. Spain had to wait until 1978, once democracy came into force in Spain to ratify it. But it's had to be ratified by all three countries. So, and as I was telling you, the Geneva Convention establishes who is a refugee. So that's something I wanted to ask you. Would someone take the floor and tell me what he or she understands under the term refugee? Anybody? Or shall I pick someone?
Well, I understand that it's the person who has to leave their places and cross the border of their country because of persecution related to religion or different reasons of persecution, or it's I think it's also the fear of their life. I think it's that.
Okay, great, Mercedes. Well, you're very near. Yes, you have, I think, mentioned some of the most important elements of the definition. Let's go to the literal definition that is contained in the Geneva Convention, and you will see that you got it right. It's Article 8.2 of the 1951 Geneva Convention, and it establishes that a refugee is a person who is outside of her country of nationality or habitual residency, has a well-founded fear of being persecuted because of his or her... Sorry, someone has the mic on? Thank you. Because of his or her race, religion, nationality, membership of a particular social group or political opinion, and is unable or unwilling to avail him or herself of the protection of that country or to return there for fear of persecution. So you've seen that I've highlighted some aspects in blue. This is what we normally call the elements of the refugee definition. Let's talk a bit about these elements. As Mercedes pointed very well, we are talking about someone who is outside his country. This is very important because a person becomes a refugee when an international border is crossed, which means that person who flee and stay in their country are not refugees. That does not mean that they are not in need of protection, but they are not considered refugees in the meaning of the Geneva Convention definition. It's important also to keep in mind when we talk about someone that is outside, has crossed an international border, it's not necessarily that the person crossed because he was being persecuted or had a fear of being persecuted. That's not the determining fact. The important thing is that the person cannot return because of that fear or that persecution. What that does mean? What does that mean? That means that we can, for instance, find people that left the country long ago for different reasons. Suddenly a situation happens in the country, a conflict, a change in the laws, etc., that make this person that makes it impossible for that person to return, because if he returns, that person would be in risk of being persecuted. So that's clear. You understand that? Should I put some examples? For instance, in Spain, back in 2014, a rise started in the number. A conflict started in Mali. There was around that years there was a coup d'état. I don't know the English term for that, which determined that a lot of people fled the country. There were already a lot of Malians in Spain working mainly in agriculture that had come through the different sea routes and that were had been for many years in Spain. Well, these people didn't leave the country because there was a war or a conflict there. There was a change in the government. But at the moment that this happened in their countries, they became refugees. So they did not leave the country because of the fear, but they were considered refugees because of that fear of return. So that's clear for all. And as I was saying, what's important also is that the important thing is not why you fled, but that there is something happened in your country that makes it impossible for you to return without risk. Okay? That's about the first element, being outside the country. The second element would be to have a well-founded fear. It's not only fear. I mean, fear is a subjective element. It's something that anybody can have fear of many things, which are rational or not rational things that we fear. So there has to be, in the case of a person to be considered as a refugee, the fear of being at risk of being persecuted has to be well-founded. We say that there has to be a reasonable risk, a real risk, good reasons or grounds. There needs to be a valid basis of that fear. This is a very silly example, but if someone comes and says, "I left my country because the aliens were arriving," with all my respect, but I think that nowadays that wouldn't be a legal basis for becoming a refugee. So the fear has to be founded in reality. And that means that we have to consider two aspects. For on one side, the personal circumstances of the person who is asking for protection, which can put that person in risk. So it has always to be an individual assessment. And what we call, which is a very important aspect of working in determining refugee status, what we call the country of origin information. COI, or country of origin information, is one of the key elements we need to take into account when we are determining if a person is or not a refugee, because that's what will give us the information about the foundation of the fear that the person is claiming to have. It will give us an information of if what the person tells us that happens in the country really happens in reality. It's not only about what is the legal framework and if there are laws prohibiting things or laws allowing things, or it's also about that being effectively implemented, how, by whom, and how easy is it to access this the protection or from the national authorities, etc. So all these aspects have to be taken into consideration when we talk about the fear, the well-founded fear. And the third element would be, of course, the persecution. So what do we call persecution in the terms of the refugee definition? We are talking about, I talked about that earlier, a serious violation of basic human rights, but also other harmful acts or threats that can accumulate, and when they accumulate, they can amount to persecution, even if they are small. So this persecution has to be linked to any of the grounds that you see as the last element of the definition. But talking about the persecution, what is also important to take into account is who is persecuting you. This is a very important issue in refugee protection, because if you see if you go back to the definition, we talk about the country that you are unable or unwilling to avail the protection of the country. The country is not willing or cannot provide protection. This means that you can face a situation where a person is being persecuted by their authorities. That would be what we all have in mind: a person that has to flee because the authorities are persecuting that person, are violating the rights of that person. But we can also face what we call non-governmental agents of persecution. For instance, if we are in a place where armed groups are, non-official armed groups are acting, where there is a conflict and there are some parts of the country where armed conflicts armed groups are acting, and they might be the agent of persecution if your own authorities cannot protect you against that persecution. You always will have to look first at your national authorities to protect you, but in many situations the authorities are simply not capable of providing that protection. So that would be a persecution from a third party, from a non-governmental actor, which can make you become a refugee. But it can also be the general population if there is a general discrimination, for instance, against LGBTIQ plus people in some countries, even if they are not. You can find, and there we go back to the country of origin information. You can have countries where being gay or lesbian is punished by law, but even if it's not the case, maybe there is such a strong discrimination by society that is amounting to persecution. So the general population can also become a non-governmental actor of persecution. And depending on the personal circumstances, we can talk also about, for instance, family members or a small community where you live in, if nobody else in the country can provide protection against that persecution. Okay, so about the persecution, just to keep in mind that it's a serious violation of human rights, and that the agent of persecution is not only a state agent, but it can also be a non-state agent. And this is very clear. In another very clear situation is where there is a situation of lack of state or of general violence, which is normally the situation when a general conflict erupts, and in the longer term, the governmental structures very frequently collapse, and so there's no one even to turn to for that, to avail for that protection. So and the last element of the definition would be the grounds. That's important. You will be considered a refugee if you are outside your country, you have a well-founded fear of being persecuted. Important to remember, it's not that you have been persecuted only. If you are being persecuted, of course you're a refugee, but it's the well-founded fear of being, the risk of being persecuted that is important. Even if you were not persecuted in the past, but the circumstances determine that risk exists for you. So on the grounds, Mercedes mentioned some of them. She mentioned religion. We have also race, nationality, membership to a particular social group, or political opinion. Is there any of these terms that you would like me to talk a bit deeper about? Is it clear for everybody what it is when we talk about religion, about race, nationality, political opinion, being the member of a specific social group? Yes, Mercedes, I can only see 4 of you on the screen, so if you just just open your mics and talk, no problem.
Okay. Well, yesterday we talked about some intercultural concepts, and race is one of perhaps the one that I would like to know about today, to integrate it with what we've seen yesterday.
Yes, that's a great point, Mercedes. You have to keep in mind that the Geneva Convention is from 1951. So that means that the terminology is frequently a bit different of how we would call things nowadays. So when we talk about what in 1951 was called race, we would call it, let's say, ethnic groups nowadays, with all the white all the width of the term, or all what that includes. It's true that it's very frequent that grounds of the Geneva Convention, like race, religion, nationality, are kind of mixed. It's normally not that clear that a person's situation is just you can put it in one of these grounds. It's very frequent that we have them mixed up. Race, religion, nationality are very frequently mixed up to determine one's identity. So we would talk about, for instance, nationality. Also, we talk about it can be citizenship, but it can be also ethnic, religious, cultural, or linguistic communities. When we talk about race, we talk about ethnic groups. So it's kind of a bit of a mix. But as soon as you can identify a group with some common characteristics based on nationality, religion, race, etc., or ethnic groups that are identified and targeted and persecuted, then we can talk of grounds on the Geneva Convention. Yeah, that about that. Anything more that you want me to go a bit deeper into? Maybe about religion. Some comments on the ground of religion. It's not only to profess it or not profess it. It's also the freedom to change it that can be threatened, that can pose a risk, and the freedom of worship. It's the active and the inactive part of having or not having a religion, of living religion in freedom, that can determine that you are targeted and persecuted if you're not following the traditions, the customs, or the or what the laws establish in a one specific country. So religious minorities are very frequently one of the group that is in specific context very much the target of persecution.
Maria
Yes, Susana.
Antonio asked for gender.
Yes, that's a good question. Well, there we go to that big group that, well, in that sense, we can say that the 1951, I stress that Geneva Convention had the view to incorporate like a term that would permit the Geneva Conventions to become not to become outdated very quickly. And that term of membership to a particular social group, because the definition, I put it again, speaks about membership of a particular social group. That means that the persons that this would mean a group of persons that have a common background or customs or a similar social condition, be it family, be it a specific profession, or maybe being part of a trade union, or being a journalist. That would be a specific social group that can be targeted in some context. And LGBTIQ plus persons are considered there, and also women can at some point be a specific group. Children are also a specific group who can be specifically targeted and have and experience specific forms of persecutions pointed at children as well as women. So Antonio, gender can determine that you are in a specific social group and that puts you at risk, or it can be a characteristic, an element that can determine specific forms of persecution, or that you are at a higher risk of being persecuted. So yes, it's definitely through this membership into a particular social group where we can channel all these kind of groups. Okay, so what would be then, if we see again the definition, a refugee is a person who is outside his or her country of nationality or habitual residence. Can someone tell me why does the Geneva Convention talk about a country of habitual residence? Doesn't that strike you? Okay, this is meant to include in the refugee definition stateless people, stateless persons, those who do not have a country of nationality, but of course they have been, or they live in a place they call, I don't know if to say home, but it's a place where they live. So if you have a place where you normally live, but you don't have any nationality, you become a refugee if you have to leave that place and go to another country, cross an international border because of the grounds set out in the definition. So that's the way in which, through which the stateless persons are included. As we were saying, that person has a well-founded fear of being persecuted because of his or her race, religion, nationality, membership of a particular social group or political opinion, and is unable or unwilling to avail himself or herself of the protection of that country or to return there for fear of persecution. So that brings me to the two key questions that we have to ask a person when that person claims to be a refugee or asks for international protection when arriving into a country, which would be these two key questions. Why did you leave or flee your country? What was the trigger for you to leave? Were you persecuted? Were you at risk? And why can't you go back to your country? Okay, so with these two questions to anybody, you can start to see if that person would not be a refugee. It's the ground for which you left your country, but more importantly, the ground for which you cannot go back to your country. And if it has to do with the grounds set out in the definition of the Geneva Convention, we would be in front of a refugee. When putting that into practice by states, which are the ones that have the international obligation to grant, to recognize protection and to provide protection to those persons who arrive at their borders or to their countries and ask for asylum, that's a different story when we go into practice, when we see the different circumstances, when we see how states organize themselves in their procedures and their support systems to determine who is a refugee or not, how well these systems function or not. Some states who are not capable of setting up a proper asylum system to determine if a person is or not a refugee and to provide the protection that the refugee is entitled to by the international obligations assumed by the states. In these circumstances, it's frequently UNHCR who assumes the refugee status determination, what we call refugee status determination. And that's what we will call refugees under UNHCR mandate. In Germany, in Sweden, or in Spain, there is a functioning state and a functioning protection system. We'll talk later about how it looks like in Spain, but I invite you all, of course, to also see how it is in your other countries, which being all EU countries, we'll see later what the European framework is for refugee protection. They are similar, but you will also find out that they are important differences and frequently important different outcomes depending on how the protection system is established, what model there is. So any questions so far? Nothing? Either everything is clear? Okay.
Is correct to speak about climate refugees in this conception that you...
That's a very good question, Susana, and that will be one of my questions at the end of the session. So just keep that question and we'll go back to that at the end of the session. That's a controversial point nowadays. So let's see what we all come up with together at the end of the session. Okay.
Thank you.
Great, very good question. Yes.
Okay, I asked in the chat an important question that for me is who decides what is well-founded fear? No? Every country is not the convention because every country, that's what their interpretation, no? Because some refugees explain to the authorities their situation and they depends that they are in the hands of the opinion of any particular country. Because for me, for example, there is always a controversy between economical immigrants and refugees. If you belong to a group, a social group in your country that are discriminated because they are poor, for example, they don't have defense, no, they are unable to fight against the authorities because they are in a casta, no, in the caste. In the many of them used to come here as the Spanish authorities, they say economical refugees, not refugees, immigrants, because they want to return to their countries with money to help the family or send money to the family to shift to another social group, more protected group. They can pay security, for example, in their countries, if they have money. So here, and I have many questions about that. The other is why Spain is not a model of a country, a receiving country of immigrants, of refugees, I think. Because what about the return of refugees in war, no? Very, without any study,
we call the pushbacks.
If they are children or they are adults, here in the refugees centers, many of them want to be children or try to be children, to live in an apartment, not in a because they don't want to go on to Europe, go on to Spain and through Spain. Spain is like Morocco, I think. No, sometimes it's a passage to Europe.
Yes, you're Antonio, right?
Yeah, no,
okay.
finish. No,
it's just because I'm not seeing you on the screen, but from what you are telling, I presume you are Antonio from La Laguna.
Yeah.
So you've raised a very, very important issue, a very complex one, and a very sensitive one from a political point of view also. As I told at the beginning, and that's why I stress that we have a strong legal framework on refugees internationally, which we do not have for other migrants. We can, of course, discuss about the grounds of why people flee poverty, and I mean, not why, but to what extent people fleeing poverty and all these circumstances should be or not recognized as refugees. For the time being, we have that very strict definition, and that protects a lot of people. What the challenge we have in a country like Spain is that we have here what we call mixed flows. That means it's mixed migration, which means that through the different migratory channels, and specifically to the Canary Islands, we see the arrival of a lot of different persons in need of protection for different grounds. We found refugees among the population that is arriving to the Canary Islands. We find people because we find persons that are coming from conflict areas, from the Sahel, from Mali, from Burkina, from all these countries. We have children that have to be protected as children, and then have to be, first of all, identified as children and then protected as children. We have persons, and specifically women, that are survivors of violence and of gender-based violence or of exploitation, sexual exploitation, and so we have all this mixed into the flow of person that is arriving to a place like the Canary Islands. What is key is that when these people arrive, they have the opportunity to be identified and their needs are identified, and they are channeled to the adequate path, be it child protection, be it refugee protection, be it protection against exploitation. So that's a big challenge. We could talk for hours about that, I'm afraid, and you would certainly have a lot to say, Antonio, about your first-hand experience on that. But yes, you've pointed to one of the most important challenges in Spain and in other countries, southern countries in Europe, which is the access to the territory and access to protection, and the elements that have to be there for that to happen. So, any more comments or questions? Okay, so I wanted, yeah.
I have one question. What about?
Hi, Pilar.
Hi. What about the idea of this freedom of movement? Because the point is what Antonio said. Many times when refugees come, we have this, especially in some countries, for instance, Australia or in the Great Britain, I think this kind of immediate detention. We keep refugees in detention centers. So, what about the freedom of movement? When can they? Yeah,
that's you're pointing out all the very big issues this afternoon, which is really very interesting. When we talk about refugees, the UNHCR policy is that detention should be the last solution, the last mechanism to resort to. That people are left without freedom of movement is serious. So when it comes to a person that claims wants to ask for asylum, detention should not be the solution. What we face in a context of sea arrivals in Spain is that the legal mechanism that is in place is you arrive in an illegal way to Spain, in an irregular way to Spain, sorry, which determines the legal framework establishes that if you arrive in an irregular way to Spain, you can be a procedure to expel you or to return you or to reject you is started. And in order to make that expulsion effective, you can be detained, but always in a legal framework. And that very importantly includes that you are informed about the possibility to ask for protection, and you have the possibility to ask for protection. So information in that first arrival is very important. One of the materials that I'm going to share with you are some videos that the UNHCR office has produced this year, specifically directed to persons arriving by sea, explaining what is international protection, how to self-recognize oneself as a refugee, what one person has to do in Spain upon arrival when wants to ask for protection. In different languages, we're translating that into all kinds of languages that we know that persons arriving to the Canary Islands. So I invite you also to take a look at these videos when we share them later. But yes, about freedom of movement, you're absolutely right, Pilar. And in fact, in the cases in Spain that a person that arrives, the minute that person indicates that he wants to claim for asylum, that person cannot be kept in detention. Detention for irregular arrivals can only be established for persons that are going to be rejected or expelled, and for a limited time. If the expulsion is not effective in that limited time, then the person has to be left in freedom, even if in an irregular situation. So yes. Any more comments or? Okay, well, I wanted to touch upon that last aspect of the Geneva Convention that I told you that is very important, and that is this cornerstone of the international protection. If this does not happen, and it has to do a lot with what Antonio and Pilar were indicating, especially Antonio, then all the international protection system not worth. I mean, it doesn't exist, which is the principle of non-refoulement. This is what the Article 33 of the 1951 Geneva Convention says. It says no contracting state shall expel or return, refouler in French, a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, etc. So what the Geneva Convention established in 1951 is that any person that arrives in a country and claims for asylum, there has to be a procedure to determine if that person is or is not a refugee, if there is a risk or not for being persecuted on account of these grounds, before that person can be sent back to the place where that person came from. This is very important, but because this does not only protect a refugee once the person is recognized as a refugee. If you are recognized as a refugee, you will obtain a documentation to legally reside in the country where you have been granted protection, and you will be provided with a passport, what it's called the the Geneva Convention passport, or the blue passport, which allows you to travel all around the world, but not to your country of origin, because you're asking for protection, because in your country you are persecuted. So that's how important this principle is. But it's so important that it does protect not only refugees, it does protect any person that applies for asylum. From the minute that the person applies for asylum, the principle of non-refoulement, in Spanish, for the Spanish speakers, el principio de no devolución, protects the person who applies for asylum for the minute that the person expresses that will. It doesn't mean that the person has to have any documentation or has to be registered. It's just from the moment that the person expresses it that the protection should be in place. In practice, that's tricky, that's difficult to protect a person that has only expressed the will to apply for asylum. But any authority that comes across of a person that does this has a duty to protect a person against refoulement, against being sent back to the place where the person came from, until it is determined that the person is not a refugee. In the case that it is determined that that person going through a procedure is not a refugee, then that person can be returned, can be expelled, etc. But even more, that principle has become so important that it protects not only asylum seekers and refugees, but it has become what we call a rule of customary international law. And it's that no person, not only a refugee, not only an asylum seeker, no person should be returned to a country where they face serious threats to their life or freedom. That means that before expelling anybody to a country of origin, there has to be a procedure. There has to be a procedure where the person is identified, where the person has the opportunity to express if for any reason linked to the Geneva Convention or not, that person should not be returned, and that protects us all from being sent to a place where we face threats to lives or freedom. Putting that into practice again is difficult, and going back to what Antonio was saying about returning persons without a procedure, about las devoluciones en caliente, what we in English call the pushbacks, that's the key aspect of that. What this kind of operations do imply is that the person is not given the possibility to, in a proper procedure, with a lawyer, with an interpreter, with adequate conditions, to express if the person can or cannot return to his country. So if you only from today retain this principle of non-refoulement, that would be great. That would be a success for the session today, because it's the basis. If a person arrives, does not have the opportunity to express him or herself, and before that happens, that person is sent back, then all the international protection regime is not worth anything, because at that first moment, the state obligation failed. Okay, so I hope this is clear for everybody, and you take it with you for the rest of your life. Okay, so this would be the two basic aspects of the Geneva Convention I wanted to talk about you. What is a refugee and what is the principle of non-refoulement? But there are other basic concepts in international protection, and I wanted to just go through them quickly with you. These are some terms that I think are important for you to know the differences. So anybody wants to jump in, pick one of these terms, not refugee, we've already talked about refugees, and explain what they understand behind these terms. So feel free. Anybody? Or shall I start picking people? For instance, Dolores, are you there?
Yes, there is something I have always found a bit confusing, which is the difference between a refugee and an asylum seeker.
Okay. Okay, that's a good point, and that allows us to explain. A refugee is a person that after going through a legal procedure has been determined to be a refugee, where the person has been interviewed, has had the possibility to present evidence or what we call indications of a persecution, where this has been analyzed, and where an authority has determined that that person fulfills the definition of the Geneva Convention we have just seen, and therefore that person is recognized officially as a refugee, provided documentation and all the rights attached to it. That's the classical term of refugee. We can find situations of what we call surplace refugees. That's when, surplace prima facie refugees. That's when, for instance, that happens when a country neighboring a conflict sees the arrival of nationals of that country in conflict. So you probably will not need to go through an individualized procedure for every Syrian that arrives in Lebanon, because any Syrian fleeing the conflict, apart from considerations that might exclude the person from the refugee protection, but that's another more complicated part of international protection. For the only reason of being Syrian, that person will be a refugee. So so refugee is when it's clear, it's determined. An asylum seeker, or as I write, as you can see on the screen, an international protection applicant, which is the same, is the person who has made a claim for asylum and is waiting for a final decision on his claim. So that's the difference, okay? So one thing is the number of people that arrive in a country and apply for asylum, ask for asylum or for international protection. And the other thing is how many recognized refugees are in a country, okay? But when we use we also use the general term refugees to refer to all the population that is forcibly displaced because of the grounds of the Geneva Convention. So you can also use the term refugee in a wider sense.
Okay. And there is one more thing, perhaps we can wait, because this is, you see, since, as I said before, I'm very much concerned with all the horrible things which are happening in the Australian detention centers. I mean, all of these islands. I mean, I'm thinking of Christmas Island, Papua New Guinea, the islands which have been excised. That is, I mean, the government decided that they were no longer part of Australia. I mean, they were no longer Australian territory. And it is there that all of these people are being confined. And we know, I mean, that in many cases, well, they can be there for years, many years, and nobody cares about, their situation. And some of them are sent back. So my question is, we know many countries, I mean, I'm thinking of Australia, but of course the list is much longer. They are not complying with the law. I mean, they are not doing what they are supposed to do. Now, is there anything that, you know, the international community can do, you know, to, I don't know, to change the situation? Because we know this is happening, and it seems there is nothing we can do to stop that.
Yes, you're absolutely right. I mean, it's a complicated issue. First, of course, as UNHCR, we have a responsibility on pointing at these kind of situations, or the risk of what we call outsourcing of asylum, because the state is bound by its international obligations with refugees and with asylum seekers in their territory. But it's not that clear that when that persons are taken outside the country, these international obligations remain. It's not a path that we would like to see spreading around. Australia is one example. The UK has recently also very timidly started, although they have been talking for many times about what they call safe havens and then outsourcing of asylum processing. This is a very risky procedure and model, and we as UNHCR are really very concerned about that. And international community, I mean, there is the legal framework and the legal obligations, and there are the examinations that countries have to go through by UN bodies and their human rights records are screened and examined, etc. But it's not an easy issue to tackle, and it has to be an effort of all the international community to point at this kind of practices and make countries to go back. But it's not an easy task, and yeah, I'm afraid in that sense what I would say that the legal instruments we have, the force we have in the international community is not that strong.
Yeah, that's the beauty. Yeah.
Yeah, that's it. So, anybody? Thank you, Dolores, for your comments. Anyone that wants to jump in on any other of the terms? We've talked about refugees, asylum seekers. We've talked earlier about stateless persons also. I think that it would be clear what a stateless person is. They are also under UNHCR's mandate. And a stateless person, who is a person without nationality, can be apart from being stateless, can also become a refugee if they, as a stateless person, they fulfill the refugee definition. Spain is one of the few countries, although in the last years some countries have made it also, have put it up, that has a specific procedure to determine a person as a stateless person, different from the asylum procedure. It's under the same authority, the Ministry of Interior, the Asylum and Refuge Office, but it's a different procedure, and they are recognized as stateless persons and differentiated from the refugee status. What about internally displaced persons? What we call IDPs? What do you think we are talking about when we talk about IDPs? Remember, we talked about the refugee being a person that crosses an international border. When we talk about internally displaced persons, we talk about a person that has not, that remains within the borders of his or her country, but had to flee because of persecution, or because of conflict, or because of different circumstances, including in this case, for instance, climate phenomena. So these persons are not covered by the Geneva Convention. They are not considered refugees because they have not crossed an international border. But at some point of UNHCR's work, the UN General Assembly decided that UNHCR should also cover the protection of IDPs, of international displaced persons, And we have not now also the mandate to protect internally displaced persons, which when you see the figures of displacement worldwide, it's a much higher number than actually refugees, than people that crosses international borders in countries like Colombia, for instance, or now in Ukraine. The number of people that are internally displaced because of persecution and conflict is sensitively higher than those that actually are leaving the country. So that poses different challenges and different protection problems. A returnee, what would you think that a returnee is? We've talked about durable solutions at the beginning. We've talked about integration. We've talked about third country solution, and we've talked about return. You remember? So what is a returnee? Who is a returnee?
Well, I guess somebody who has returned to his or her country of origin, but is still in need of help.
That's it. Very good, Dolores. That's actually a refugee who returns home.
Yeah.
To return, as I explained earlier, there have to be certain conditions have to be met. So of course, anybody has the right to return whenever that person wants. But when do we promote or assist or even assist people to return? It's when the circumstances that's motivated the person to flee are no longer there, and whenever the return is in safety, in dignity, and always voluntarily. So that's not the case in Spain. We have not refugee populations that have been returning in high numbers to their countries of origin, only in very little numbers and to very concrete situations. And well, maybe it's the thing that we will face in the short future with Ukraine, because that's the biggest refugee situation that the EU has faced in the last years. It's clearly the highest number of refugees that we are receiving in all European countries nowadays, and it's very likely that once the conflict ends, whenever it ends, and conditions are there, return of Ukrainians will be promoted. So we will be facing returnees, which will be something very new in the European context. And the last concept, maybe more complicated to you, is what we call humanitarian reasons or grounds. I'm going to explain a bit on that, unless someone wants to jump in and has an idea of what we talk when we talk about humanitarian reasons, which can be understood very differently in the different countries and contexts. Humanitarian reasons is a status which is different from an international protection status. It's not a refugee, it's a person that cannot return to his country because of humanitarian reasons. And it's a type of protection that many, specifically EU countries, do have in their legal framework. Spain has it, very specifically with the Venezuelan population. People that are fleeing Venezuela is again a mixed flow. That means that there is a political conflict in Venezuela that has determined that humanitarian conditions in the country are very harsh. So we will find people that are leaving the country because they are actually facing persecution, like the definition we've seen from the Geneva Convention, but also a lot of people that are not directly facing this kind of persecution, but because of the general humanitarian situation, they cannot return. So, and that is something that after being determined by some judicial decisions, because Spain was not granting humanitarian protection to Venezuelans, but some judicial decisions came to change this. And now the Spanish authorities are granting, in the majority of cases, to the Venezuelan population humanitarian status, because it's understood that Venezuelans cannot return to Venezuela due to the humanitarian situation, which does not mean that among the Venezuelans in Spain, they are not people that are recognized as refugees, because they do fulfill the refugee definition. In the case of Spain, this status, we will talk about it later, but provides some more limited rights than the refugee status. Okay, and I wanted to well, we'll talk about later also about another concept, without see now I haven't put in this slide, which is complementary forms of protection or subsidiary protection. This is something that did arise in the EU in the context of the European Union, and it is that a lot of European states have established do not grant only refugee protection, refugee status, as in the Geneva Convention, but they provide, in cases of conflict, of people fleeing conflict, what they call complementary protection or subsidiary protection. Spain has also this kind of status. We'll talk later about what it entails and what it means, but just for you to know that it's a different, a complementary form of protection in the EU context very frequently, okay? And we'll see a bit of the differences between one and another. It has to do with the grounds. If you fulfill the refugee definition, that means that you have a well-founded fear or of being persecuted for the grounds, for one of the 5 grounds that we've seen in the Geneva Convention, then you are a refugee. If you have a fear to return to your country because there's a general violence, there's a risk for your life or your integrity due to this general violence, then you will be recognized, you will be granted subsidiary protection in the case of Spain. Which does again not mean that people fleeing a conflict, generalized violence, in their individual case, they can be recognized as refugees, is if in their individual case it is evaluated that the refugee definition is in place. Okay, so that's a bit all the spectrum of basic concepts on refugee, the refugee definition, international protection, and all these terms. So any question, any comment until now? Anything else you want to raise? Yes, Dolores?
Yes, one question. I take it that stateless people find it rather more difficult to ask for asylum. Am I right? I'm thinking, we know cases in which sometimes, especially people, trying to arrive in Australia by boat. I know I'm talking about Australia all the time, but as I said before, this is what I know best. And I guess we can draw parallels if we think of other places. But sometimes it is the very authorities that try to get rid of all of these documents because they want these people to be stateless.
Okay, one thing is your nationality, and even if you have a document to prove it or not, you have a nationality, and the other thing is when you're stateless, it's not that you do not have documents to prove your nationality, is that no country in the world recognizes you as a national. So that doesn't mean that in practice, in both situations, when you are an undocumented person or when you are a stateless person, you may face in practice similar difficulties or challenges. But it's a bit different, and that's why, yes, any person that cannot prove its nationality, but nationality is proven not only in the framework of a refugee determination procedure, it's very frequent that people cannot produce documents that prove their nationality. So nationality or any other circumstance of a refugee has to be proven not by documentary evidence, but very frequently by the story of the person itself, its coherence with this country of origin information, which we talked about earlier, and by indirect means like nationality tests, which are not perfect, but sometimes they are useful. Nationality tests are made when it's not possible to determine the nationality of a person that arrives applying for asylum, because there is no document to prove it. But it can be proved through indirect ways because of the language the person speaks, because of what the person knows about the country, because of the story the person tells. So these are indirect ways to prove the nationality, even if there is no document to prove that nationality, which is very frequent in the case of refugees. In the case of a stateless person, you will never have any document that proves the nationality because that person has no nationality. You may have a document that proves where that person was born, where the person has lived, but no evidence of a state or a country that would recognize that person as a stateless person. And yes, it's frequently, it's one of the main challenges with stateless person is for them being recognized as stateless person and being provided with documentation because they are stateless. Because you have to go through all a procedure to determine that those countries to which you might have a link in your life are not recognizing you as a national, and that's a very bureaucratic and complicated
that's the
procedure.
point. That's a very long procedure, and the authorities must be willing to carry it out.
That's a point also, the
If
willingness
they're
of
not
authorities.
willing to do that, then the situation is very different.
And we have a lot of refugee populations that start to become stateless because of the nationality laws. That means that, for instance, we have countries where the nationality is only given to the children if it's the father, the one that passes the nationality. So if the father, for instance, is no longer there, is absent, that it's only the mother with the child, and the mother cannot prove in any way that the child is a child of a national of that country, then that child would become stateless. And that's very frequent in refugee situations, that because of the nationality laws, a refugee population start to also become stateless population in the second generations.
Thank you very much.
You're welcome. So I just wanted to touch briefly to end this part on that European context that I talked about earlier also. Very briefly, in the EU context, I'm talking about the European Union. We have a specific legal framework with it's good that you are familiar with it. Very shortly, in the EU context, the goal is to establish what is called a common European asylum system. It's the SEAS, and in Spanish, the SECA, Sistema Europeo Común de Asilo. And how is this done? It's done through the adoption of the legal instruments you see there. There was a first generation of legal instruments who tried to establish minimum standards for all European countries in all the different aspects of a asylum system. We are now in the second generation of these documents. So these legal instruments were reviewed and where we have now what is called the recast directives and recast regulations. And we are now in the middle of the negotiation of the third generation of these documents. And this path takes us to slowly to a stronger legal, more binding European legal framework. First, we have directives, some regulations and some directives, as you see them there. You know, directives are not directly binding in the European context. They have to be transposed to national legislation, whereas regulations are directly applicable at a national level. So regulation is a stronger EU legal framework than a directive. The first, as I was saying, the first generation of directives established minimum standards that the countries should have in place in an asylum system. The current establishes standards which everybody has to comply with, not minimum, it's standards for everybody. And the third generation of documents, if we get there, but it's being a very harsh negotiation, once some of these directives will slowly become regulations, so directly binding for everybody in the EU. A small comment on what are these legal instruments. We have three directives that are, well, four, sorry, directives that are addressed to refugees and to how refugees are treated in all EU countries. First, it's the qualification directive. The qualifications directive establishes who is a refugee, what are different protection regimes that can be established in the EU, which is the refugee status under the Geneva Convention. Very important. The basis and cornerstone of all this legal framework is the Geneva Convention. All the EU countries are signatories to the Geneva Convention. The EU itself is a signatory to the Geneva Convention. So the EU framework establishes that. That means that nothing that is established in these directives can go against what is established in the Geneva Convention. So the interpretation of all the European protection regime has to be in coherence with the international protection regime. That's very important. So first we have this qualification directive, which establishes refugee status, possibility to establish complementary forms of protection, as I told you about the subsidiary protection regime in Spain. We have the procedures directive. It establishes how the procedure to determine the protection of a person has to be, what elements have to be in that procedure. The reception conditions directive, it establishes that this, as you can imagine, the conditions for the reception and support of persons that are applying for asylum in the European Union, the standards that have to be there for people to be able to live in dignity. Conditions have to provide have to respect the dignity and have to provide for adequate levels of dignity for asylum applicants. We have the temporary protection directive, which for long years, when we were training people about the EU context, we used to forget that directive because it has never been put in place. Now it's the trending topic in international protection in the EU. It's the directive that has been activated for the protection of the Ukrainians. This directive, which was drafted after the conflict in the Balkans, was established in order to allow for the EU countries to very rapidly respond to protection needs in a situation of mass influx, which is what is currently happening with the Ukrainian situation. So it's for the first time that it has been activated. Now we'll talk later about this regime of temporary protection and how is it implemented in Spain. And then to complete all this, we have two regulations. What I call the Dublin regulation, that's not its official name, but it's called Dublin regulation because the origin of it is actually the Dublin. It wasn't a treaty, the Dublin Treaty, which then became an EU regulation. And it's called the Dublin III regulation because we have had already 3 Dublin regulations. The regulation determines who is the state responsible for the examination of an asylum claim in the EU, of a specific asylum claim. This is made in order to avoid what has been called asylum shopping in the past, which is that a person goes from one country to another applying for asylum in case of rejection in one country, or because the person considers that the conditions or the protection regime or the status is better in another country. So how did EU countries design a mechanism to avoid that? That is the Dublin regulation. It established a hierarchy of rules of who would be responsible to examine a claim in the EU. So the first rule would be where the first country where a person arrives is responsible for examining the claim. The second rule would be the country that has provided a visa or a residence permit that has allowed you to enter the EU, even if it's not the first country where you arrive. So for instance, if you arrive in Spain and you have no other connection to any other state, Spain would be responsible for your asylum claim. If you arrive in Spain, but it was Portugal who provided you for a visa that allowed you to enter the EU, but you arrive in Spain, then it would be Portugal who is responsible for your claim. What is the main effect of this? The main effect is that once your claim is registered in one country of the EU, no other EU country is going to allow you to apply for asylum, unless it applies what is called the sovereignty clause. So at any time, any country can decide, okay, it should be Spain examining your claim, but I will accept you. That is normally done because of humanitarian reasons, because of family links, or any other reason. But there is a whole system established in Europe that when a person claims asylum, and it complements the Eurodac regulation that you have also on the screen. The Eurodac regulation establishes a system for the fingerprints to be taken and uploaded into a EU-wide database. So whenever a person, and this is an accompanying regulation to the Dublin regulation, whenever a person claims for asylum in an EU country, the fingerprints will be taken, they will be uploaded to the Eurodac database, and if what is called a hit comes up, that you have that either you entered the EU through another country, or another country has provided you with a visa with a residence permit to enter the EU, or you already claimed asylum in another EU country, then automatically your asylum application in that second country, will close your application and will either tell you to go back voluntarily to the first country if you want to claim for asylum, or even forcibly remove you and send you back to that other country. So that's how the Dublin regulation works to avoid as I said, the asylum shopping. These legal instruments are complemented with the action of the EUAA, which is the European Union Agency for Asylum. This is has been very newly created. We had the EASO, the European Support Asylum Office, which did not have the status of an agency prior to the EUAA. The EUAA started its work in January this year, but it's the former EASO. It's now the EUAA, which means that they have more capacity and more possibility to impose different aspects. The agency aims at these common European asylum systems to be implemented by the states, so that all these regulations are implemented. They also can become operational. They can support states with staff and with technical support. They are, for instance, in Spain, supporting operations in the Canary Islands and supporting a review of the reception refugee reception model. So they are the European Union agency to support countries in their asylum systems, and with the aim for this harmonization of practices and of laws around refugee protection in Europe. And then I mentioned also Frontex. Frontex is the EU border agency, and they are more linked to control at the external borders of the EU and supporting states that are at the external borders, also operationally with capacity, with staff, etc. So that's the EU context.